Let's get started because we have a lot to cover. So hello, everyone. Welcome to Renalogic's discussion of the impact of the Marietta case on the self-funded industry. Before we get started, I'd like to introduce myself and my colleague. I'm Scott Vold. I'm Renalogic's Chief Commercial Officer. I joined the company a little less than a year ago, previously having served as the founding CEO of a health information technology company and having worked at a large electronic medical records company. I started my career as a lawyer, which makes me minimally qualified to talk about things in the Supreme Court. So fortunately, I'm joined by my colleague, John Christiansen, who has been Renalogic's legal counsel for over 20 years. He joined Renalogic kind of full-time about a year ago or sometime in 2021 as our Executive Vice President of Legal Risk and Strategy. John is an expert in the Medicare Secondary Payer Act, which we'll talk about later today, as well as ERISA, HIPAA, and a variety of other laws related to healthcare. I think most salient today's conversation, John is actually a counsel of record and someone who drafted the amicus briefs in support of Marietta in this case. So John has intimate knowledge of the case. Originally, we were going to be joined by John Kluwitz, who was counsel for Marietta. That John was drawn into a conflict and not able to resolve it kind of at the last minute. So it's just John Christiansen and I, but as I said, as he was counsel of record in this case, we're all in good hands. Before we get started, just some housekeeping matters. Everyone should automatically be on mute, but if you're not, I ask you to please mute your mic. The chat should only be going to the host and the panelists. We're doing that to limit any distractions, but they are getting read. So please feel free to chat or pose questions. More importantly, at the end of today's conversation, we do want to take questions and provide answers to them, so feel free. Also, I'll say this, although I'm a lawyer and John's a lawyer, we're not your lawyers. And so anything you hear today is just our opinions. It's not to be taken as legal advice to you. There's no attorney-client relationship. So with that, let's move ahead. Here's what we're going to cover today. We have a lot of ground to cover. So we're going to start with some context. It's really important to set the case and what the case stands for in the appropriate context. So we'll talk about this statute, the Medicare Secondary Payer Act, and why it's important. We'll talk about the consequences, some of them unintended, on the kidney disease and dialysis markets from the Medicare Secondary Payer Act. And then we'll talk about some strategies that self-insured plans have put in place to deal with high-cost dialysis claims. Then we'll move into the Marietta case, and we'll go through what was decided, and almost as importantly, what wasn't reached by the court. And then we're going to spend the majority of our time talking about 5 practical takeaways that self-funded health plans and the broker and consultants and TPAs that they work with and advise them can leverage in the wake of the case to implement effectively and legally cost containment strategies. And then we'll take some questions at the end. Okay, so let me just advance this. Everyone really wants to know kind of what's the import of the case? What does it mean for everybody? Again, let's set this case in context. And once we have some important context down, I think the holding in the case will be much more intelligible, much more digestible, and the practical takeaways will be actionable. So with that, John, can you walk us through what the Medicare Secondary Payer Act is?
Sure can. So end-stage renal disease, which is the final stage of the progression of kidney disease, the point at which somebody reaches the need for dialysis, is one of the very few conditions that automatically entitles someone to enroll in Medicare. Basically, it's otherwise age or really elaborately defined disability. This kind of coverage by Medicare came about as kind of a historical accident in the 70s. It's sort of a matter of timing. And at that point, it wasn't something that actually could be done very efficiently or in very many places. So Congress just sort of added it to the law. Then it became practical to treat it And that was the birth of the modern dialysis industry as we know it. As a result, suddenly Medicare had assumed responsibility for a whole lot more care than Congress had bet on. So it enacted the Medicare Secondary Payer Act to try to shift some of the burden of coverage for dialysis over to the private sector, to commercial carriers and self-insured plans. So that's in the 1980s. What it was designed to do very specifically at that point was to coordinate benefits between Medicare and the self-insured plans to protect Medicare from becoming the kind of only coverage for individuals who needed dialysis. It did that in a couple of different ways. One is by creating obligations for private plans to cover dialysis for the first 33 months from the start of dialysis. After that, the Medicare would pick up services to that individual for the rest of the individual's life. So this is kind of a crucial period here intended to protect Medicare, and that's the root of it. Then, as we'll talk about later on, in order to maintain this protection, there are some guardrails that the statute has out there as well.
Thanks. You made the comment that it was a statute that had the effect of shifting the burden of paying for dialysis and kidney care to the private market. So the next logical question is, what was the effect of that? And in order to really unpack the effect of that, I think we need to really take a step back and say, okay, why should we care about kidney disease? What's the practical impact of kidney disease in this country? And how has the Medicare Secondary Payer Act influenced this? We're going to go through some concepts here fairly quickly, but they are, I think, really important for all of us to understand because they really serve as the factual underpinnings or context in which we find the case. First thing is this: kidney disease in this country is an absolutely massive problem, and one that is unfortunately underappreciated and underaddressed. Just to get our arms around this, or try to get our arms around it, about 37 million people, almost 14% of Americans, have chronic kidney disease or some impaired kidney function. And about 96% of those people don't know they have it. Now, there's a variety of reasons for how and why that can be the case. That will be the subject of a future webinar we're going to be releasing here soon. But just to give you a sense of the order of magnitude we're talking about for people who have some form of kidney disease in this country. The cost of kidney disease is also staggering. So the data indicates that it costs commercial health plans about $100 million a year to care for people with kidney disease. Now, kidney disease progresses in a variety of stages, going from no kidney disease whatsoever, as you see in this graph here, this is the no CKD, through what's called end-stage renal disease. That's what you can commonly think of as kidney failure. And when you reach end-stage renal disease, there's really only two options: dialysis to keep you alive, or a kidney transplantation. It's important to note that as a member moves through each stage of kidney disease, they get sicker and sicker, but they don't do so in a linear way. They move through in a very sometimes unpredictable, but often exponential way. So they can get sicker faster over time. Similarly, you see the costs go up exponentially as they move through the various stages. Now, if we think about what's going on in this country and how people are getting sicker, their rates of obesity, hypertension, diabetes are increasing, and you have so many people with undiagnosed chronic kidney disease, 96% of them, it's both no surprise, but also fairly shocking to see the statistic you have over here, which is that, in the last 40 years, the prevalence of end-stage renal disease or kidney failure has gone up 1,352%. It's mind-boggling. At any given time in this country, about 500,000 people are on dialysis, and 60,000 of them, or 12%, are commercially insured. Now, these are really important numbers to think about when we think about where Marietta came from, which I'll get to in a moment. In this country, the dialysis market is dominated by really two companies, two public companies: DaVita, who filed the lawsuit here and in several other cases, and Fresenius. And to give you a sense of just how dominant they are, they control almost 90% of the outpatient dialysis market in this country. And in some areas of the country, they are the only options. As a matter of fact, in a 25-mile radius around Marietta, Ohio, there are 6 dialysis facilities. 4 of them were owned by DaVita, and the other 2 were owned by Fresenius. So members there had no choice but to go to either one of those. Right now, here's where those numbers I talked about in a moment come into play. So, of the 500,000 people on dialysis, 88% of them, or give or take 440,000 of them, are on Medicare. So that means these 2 public companies are being reimbursed for 88% of their patients at Medicare rates. Now they're public, which means they have to meet Wall Street expectations. And so in order to grow or protect their profits, they find themselves, and we find them, overcharging commercial plans. In fact, the data indicates that DaVita has overcharged commercial plans 400 to 800% of what it charges Medicare rates. And so since 2008, we've seen the cost of dialysis services that DaVita and Fresenius have charged to commercial plans increase 400%. So as a practical matter, what that means is that if you're a health plan and you have a member on dialysis and they treat a DaVita facility, you can expect a member to cost the plan between $720,000 and just north of $2.1 million every single year. Now, I think this is one of the unintended and unfortunate consequences of the Medicare Secondary Payer Act. So, John, can you tell us how commercial plans have tried to cope with, or have they reacted to, this duopoly pricing?
Absolutely. Well, by adopting cost containment strategies. Now, what's a cost containment strategy? It can be a number of different methodologies and approaches, but at its heart, it's treating dialysis benefits differently from other kinds of benefits. There are limitations on how much you can do that, but the basic concept is to say, okay, for valid reasons, we are paying too much, we the plan are paying too much for dialysis, and we need to come up with a mechanism to do that. Existing laws, ERISA in particular, give plans the ability to do that. Other laws that apply to non-ERISA plans can help with that as well. We work with that. But the bottom line is that there are legal strategies that plans can use to carve dialysis benefits out. You need to approach them carefully. You need to manage this process very carefully, because frankly, this is a high friction area, but it can be done. You kind of work with the existing plan authorities with informed advice.
Appreciate that. When you say it's a high friction kind of environment, can you elaborate on that one? What has DaVita's reaction, for instance, been when a health plan institutes a cost containment methodology with a CARF?
Well, litigation, frankly. I mean, this is not the first round of litigation we've seen in this space. We had a serious round of litigation involving dialysis and cost containment strategies about 10 years ago. And so I guess you could say it sort of comes in waves. But right now, what we had was DaVita pursuing Medicare Secondary Payer Act claims in a shotgun manner. They fired off 5 lawsuits against different plans in different parts of the country, basically kind of that were doing somewhat different things with their carves, but they were all carving in one way or another. Of course, one of the cases was Marietta, the one we're talking about today, and the one that is getting the most attention right now. Amy's Kitchen is actually now, I think, even more important than Marietta because it's still standing. And that was one where Renalogic actually advised the plan, and has some important precedent here. But it's been litigation, and so that's what we've been seeing is kind of the response to the DaVita attempt to quash cost containment.
It's a nice segue to the next section, which is let's really turn our attention to the Marietta case. There's been a lot of coverage. I think there's also been a lot of spin, and everyone's sort of claiming a share of the case and trying to interpret it to shoehorn it into whatever they wanted to say. What I'd like to do is really unpack that and set the case in the appropriate context and really talk about what the Supreme Court decided and what it didn't. So can you very briefly give us the history of the case, walk us through kind of how we got to the Supreme Court?
Absolutely. So in all these 5 cases, the fundamental argument was that plans are prohibited by Medicare secondary payer from treating dialysis benefits any differently from any other benefit in the plan, and otherwise that would be considered quote unquote discrimination. So what DaVita was arguing was that Medicare Secondary Payer Act was really a non-discrimination statute or set of laws that was focused on whether or not somebody needed dialysis and therefore was somehow being discriminated against by not having benefits paid at the same rate as other benefits are being paid. What this is an argument for a most favored nation rate, if you will. Basically, plans being unable to carve and having to not quote unquote discriminate would have to pay at the highest benefit level available under the plan. Obviously, this is not financially sustainable for a lot of plans. Marietta in particular used a multiple of Medicare methodology, which in the way that the plan methodology was set up there, wound up paying for dialysis at 87.5% of the Medicare rate. An important point here is that the Medicare rate is intended, it's set by an elaborate rulemaking and legislative process every year, and it's intended to cover dialysis costs plus a little margin. And the reason that Marietta used it, I think frankly it's because multiple of Medicare is sort of generically a very popular approach. It's quick and dirty, it's easy, it seems like it's easy to understand anyway. And outside of dialysis, you don't have Medicare secondary payer considerations that interfere with your using it, with possible prohibitions in it. So I think that this is become, in my opinion, more popular than the risk factors actually call for. But I think that they really were, looked at what's an easy way of doing this, and that's what they came up with. 87.5%, frankly, I'm not sure what the thinking was on that, but it didn't work out well. And I think that worked out badly in particular by raising real concerns for some of the judges that this was going to upset the balance between Medicare and private plans. So Marietta won in the trial court, but the Sixth Circuit reversed the case and held that in fact Medicare secondary payer was a anti-discrimination statute, and that Marietta had violated the discrimination prohibitions by paying at 87.5% instead of, frankly, whatever the highest benefit level would have been. We don't know what that would have been, but it would have been very expensive.
You had mentioned an Amy's Kitchen case and the other cases that DaVita had filed. In reading the Supreme Court's opinion, it actually cited to the Amy's Kitchen case favorably. I think it's important for us to understand a little bit more about that case. Why did the Supreme Court look to that case favorably? Why do you say that that is the leading case on this issue?
Sure. Well, so Amy's Kitchen,
what can we take from that case practically?
Sure. So Amy's Kitchen, they used our usual and reasonable program, now Impact Protect, to reprice bill charges using a market-based approach more than anything else, sort of a financial and economic analysis, rather than just using a quick and dirty multiple of Medicare or some other methodology. But at the level of whether or not a dialysis can be carved from a plan, it posed the same issues as in Marietta. Similar arguments were made by DaVita in both cases, but they came to opposite results. In Amy's Kitchen, the Ninth Circuit unanimously upheld the Amy's plan. This actually came out after the decision in Marietta and explicitly disagreed with the decision in the Marietta Sixth Circuit case. So we have two different appellate courts. They get to disagree with each other. So that's what happened here. And the Amy's Kitchen unanimous decision disagreed with 2 judges out of 3 in Marietta, and frankly picked apart the decision in Marietta and cited and quoted the language in Renalogic in support of that argument. The Supreme Court in Marietta leaned heavily on Amy's Kitchen and pointed out the disagreement there. And so that's kind of an important indication that, yeah, Marietta is no longer good law, but Amy's Kitchen is good law. And you should look to that for some guidance in how to approach this.
Yeah, I was going to ask you, so there are disagreements among the circuit courts all the time, and that's sort of nothing new. It's not all the time the Supreme Court decides to hear a case. So why do you think the Supreme Court decided to weigh in and resolve the dispute between the circuits and adopt effectively the Amy's Kitchen rationale and not the 6 circuits?
Great question. I think there are a couple of reasons. I think one is that the 6th Circuit decision in Marietta actually was a really serious deviation from all existing cases on the point. Even in the 6th Circuit, no other court had held that it was anything but a coordination of benefits statute, but maybe had some discrimination prohibitions as guardrails to ensure coordination of benefits, but no other court had turned it on its head and made discrimination sort of the lead issue. And I think there was not only the split between the 6th Circuit and the 9th Circuit, but between all other cases, including in the 6th Circuit. And I think there was also an underlying concern that this would kind of upset the apple cart in the balance between private plans and Medicare and cause erosion of the private side, which would not be good for Medicare or for plans.
So I want to just be clear. Can you tell us exactly what the Supreme Court held in the Marietta case? Because again, I think there's been some confusion, some spin in the trade press.
Absolutely. Yeah, I mean, I consider the Supreme Court decision in Marietta to be a surgical strike against the 2 judges in the 6th Circuit. Remember, they were an outlier. This was, a new decision. And what the Supreme Court did is basically say, no, you got it wrong. And we are reversing you on that and essentially returning everything to status quo. So they didn't rule that Marietta's methodology was good, bad, or indifferent, or had anything to do with Medicare secondary payer. The only decision that they had to make was, could Marietta carve out dialysis? And they said yes, and they relied on Amy's Kitchen substantially to reach that result. But as I say, I think we shouldn't read too much into it because it was dealing with such an outlier situation.
Interesting. Okay, so that was my question, which is, did the court reach the decision of methodology, pricing and methodology, given that 87.5% of Medicare repricing seems low, and as you suggested, might have been a motivating factor, and the issue of repricing was a hotly contested issue across all of the 5 cases. So, what exactly? So we were talking about what the Supreme Court held. What didn't it reach? What didn't it decide yet?
So as I say, it hasn't decided on that any methodology in particular, and it could be multiple of Medicare, it could be usual and reasonable. There are some other methodologies out there that maybe aren't so clear. They didn't rule on any of that. And so we don't have an answer to the question of, is there a methodology that could violate Medicare secondary payer? The important takeaway from that is that that means that that's an open issue. And I guarantee you, when the large dialysis organizations see open issues that they can pursue, they will hammer into that, wedge their way into that and work on that. And you may wind up having to litigate it. What I say is that multiple of Medicare is, we know, high risk as methodologies go, not outside of dialysis, but within dialysis because of Medicare secondary payer. You've got something of a target on your back because we know that the dialysis organizations want to go after that. We've seen that in appeals and other cases, including these cases. We know that frankly, they have a really hard time reaching the Renalogic methodology because, frankly, we built it to withstand this. And we know that we've got Amy's Kitchen out there citing and quoting our language and the Supreme Court relying on it. Did the Supreme Court bless the Renalogic methodology? I'm not going to tell you they did, because they didn't. Is it clear that it is a judicially accepted methodology out there? Absolutely. So that if you want something that is reliable, well-established, and frankly, legally accepted, I think that's the better choice.
All right, I appreciate that. Let's shift gears now, because this is what I'm going to spend the bulk of our time, which is what practically can we all take away from the case? And so I think, some of that is understanding how a plan can effectively and legally implement a carve solution that has a cost containment strategy. So how should plans, how should brokers, consultants, how should CPAs be thinking about what's left to do or what's left to be mindful of in the wake of the Marietta case?
So I think one of the most important things to keep in mind is that Marietta didn't give carte blanche to just go out there and carve dialysis any old which way. I've seen some comments that seem to be indicating that. I mean, frankly, I suspect one of the things that's going to happen as a result of Marietta is we're going to see folks who've never done this before jump in because they're suddenly aware that there's some kind of opportunity here. Marietta actually didn't change the law. It changed the law back, if you will, in a very narrow way. So there are still guardrails to prevent plans from adopting methodologies or working with methodologies that would send patients potentially off Medicare. And that can come with serious consequences. Your dialysis claims payments can be reversed and wind up paying whatever it is the provider is billing. And double damages to providers. They can sue directly for that under Medicare secondary payer. There are heavy consequences. So, you need to work with anybody, but I mean, obviously, I think Renalogic is the best, but you need to work with a solution provider that actually knows this space and isn't, punting or doing something quick and dirty to get you a cheap fix.
Yeah, that's a good point. So let's talk about those sorts of things, right? So you're the expert in the field. What are some of the things that we should take away? As a matter of fact, we teed it up already. There are 5 takeaways we're suggesting a plan should take from the case. So why don't you walk us through those?
Well, so one clear takeaway, and this is something embedded in the Medicare secondary payer regulations and case law and the congressional intent. I mean, this Medicare secondary payer sounds like it's a small thing, but it's a pretty big, messy set of a statute and legislation and congressional history and regulations and cases that have been decided. And so you need to wend your way through all that to make sure you understand it all. But one key takeaway you can carry with you without learning all that is don't do something that create incentives for members who need dialysis for any reason would terminate plan coverage. Don't create additional premiums or differential premiums that would harm them, or higher deductibles, or different benefit levels that aren't justified financially, frankly. Make sure that all of those apply to anybody who needs dialysis in the same way. And you can, pull that out of Amy's Kitchen is a great place to look.
Great. Number 2?
Well, I mean, don't create incentives for members who are on dialysis or may need dialysis to switch to Medicare. And that would include things like, okay, we're going to pay for your Medicare premiums. That seems like a good solution for a lot of reasons. We'll encourage people to sign up for Medicare. Yeah, that's exactly what it is that Medicare secondary payer is intended to prevent, is plan members jumping off before the end of that coordination period. Now, remember, we're talking about things that you need to do within this 33-month period. So make sure that you're taking that into account, literally, and understand that during that period, you cannot be doing these things that violate the guardrails. So don't create an incentive for members to switch off your plan and get onto Medicare, however you do that.
You touched on the multiple of Medicare issue before, but maybe you can expand upon it really. Like you described it as potentially a lot of folks jumping in the space without a lot of expertise, multiple of Medicare as a quick and dirty way to reprice, but not one that is built to withstand legal scrutiny. So can you talk about this takeaway?
Yeah, I mean, as I mentioned, I think that this is multiple of Medicare in the dialysis space is a bit of painting a target on your back. We know that the dialysis organizations don't like it in particular. We've seen that in appeals. We've seen that in cases. We've seen that in statements that they've made. This is something that they see as a real risk to their profits. Let's be very clear about what their risk is. On the flip side, for plans, as I say, this can look like something that is quick and easy to implement. Gee, it looks simple. You take Medicare and you multiply it by something. As I say, this appears to take into account Medicare rates. Whether or not that makes it a violation of Medicare secondary payer, we don't have a ruling on. And I would prefer not to be backing up a plan that is having to litigate that. I mean, as a lawyer, of course, litigation is wonderful. I can make a lot of money doing that, or I could if I weren't in-house. But generally speaking, it's not good for plans to be involved in litigation. So this looks like it could take it into account. I guess just don't do that. And that would include not paying the same as Medicare. Frankly, this also raises the specter for paying the same as Medicare, raises the specter for the dialysis organizations to go to Congress and say, we're just not being paid enough. So be careful about doing this. And frankly, I would say just don't use that. Do your financial analyses, but if it comes to the same place, avoid multiple of Medicare. Keep in mind also that multiple of Medicare isn't actually as simple as it seems to be. You need to have language that actually works for that. The WinCo plan, which was one of the shotguns in the DaVita DaVita Medicare secondary payer cases, they got in trouble because they looked like they were repricing at multiple of Medicare, but they couldn't explain why, and they had to settle that case. And actually doing the numbers may not be as easy as you think, because there's a Medicare base rate, but then there are also additions and multipliers that go into that. So you may not actually wind up paying what is a multiple of Medicare. It may be something that's a multiple of, say, the base rate, and it doesn't withstand scrutiny. So it's not as simple as just saying multiply Medicare by X and you're good. Frankly, I think that a lot of the time, the intent behind this kind of a quick and dirty approach is to set it up so the provider will threaten litigation, and then you can settle and have a negotiated rate. And whether or not that is good for the plan, I'll leave to those who've got that negotiated rate. Of course, that's confidential, so we don't know what's in that black box. But that's what I think goes on some of the time.
John, I was going to save questions for the very end, but I'm seeing a flood of them on this particular issue. So let me kind of summarize a few of them and consolidate them into one question, which is, why not just pay the Medicare rate? Like, why a multiple of that Medicare rate? And to kind of put that another way, what's like, you made this comment before where multiples of Medicare don't really track the way Medicare rates are set up or created. So you talk about how Medicare rates are set and then why a plan just doesn't pay the Medicare rate and simply be done with it.
Well, yeah, and I mean, frankly, saying just pay Medicare doesn't get you away from multiple of Medicare. It's just a very simple multiple of Medicare. It's 1 times Medicare. So it's not actually avoiding the problem. It's just saying, okay, fine, we'll pay Medicare because that seems even easier. I mean, frankly, it isn't that easy, as I say. One way or another, you need to go through the steps of what would Medicare pay that facility for that patient. And as I say, you've got multipliers that have to do with is a complex case mix for that facility. Where is it located? Are we encouraging rural dialysis? Just there's a lot of factors.
Yeah, and I guess let me jump in there really quickly. And again, this is not intended to be a plug of Renalogic, but
Right.
if you can maybe contrast the idea of paying the Medicare rate or the multiple of Medicare versus the impact protect Renalogic methodology and how that's different, I think that'll help people understand, oh, there's a computation and different factors that go into recalibrating or rationalizing a dialysis claim versus saying, here's 120% or 140% of Medicare.
Absolutely. Yeah, well, so I mean, the reason we went for the methodology we use is that, frankly, we're trying to address the economic problem, the market problem that the dialysis providers are able to inflate rates to self-insured plans. So we're trying to say, okay, let's look at what a fair amount would be to pay to dialysis providers. And that takes into account what they get paid by everybody, because that clearly makes it work for them as well as for everybody else. It ensures that the balance is maintained, right? But it also ensures that they're getting paid something that should be acceptable in a functional market. It's something that we do the calculation for, so we stand behind that calculation. We maintain the information base and run the methodology and the algorithms to make sure that we're getting out good results. And we stand by that, and we'll stand by that in appeals and litigation if necessary. So frankly, from the plan standpoint, I'm not sure how much more difficult that is than actually running an honest multiple of Medicare or even Medicare analysis. But it's certainly something we defend.
Great, thanks. I'm sure there'll be some more questions at the end here. We're going to skip over, we're going to go through this fourth one pretty quickly, which is just don't pay less than Medicare. I think you've addressed that a little bit, which is before it paints a target on your back. It could be a reason why the Sixth Circuit reversed, and you included it. So let's get to this last takeaway, and then we'll open it up to some questions.
Yeah. So a really important point to make, and I mentioned before, the waiting and coordination periods, the 33 months from start of dialysis that the plan has to be primary. Well, one thing some plans have done is to track exactly how the coordination period runs for members. And in particular, in Virginia Mason, they changed the benefit amount that was paid as soon as the member hit the coordination period, or when the coordination would kick in if the member were enrolled in Medicare. And the Virginia Mason court held that that was improper and was in fact a violation of Medicare secondary payer. Interestingly, that was in a companion case to Amy's Kitchen. In other words, it was issued by the same three judges, same day. They heard the arguments at the same time. So they were looking at both of these together. And I think a clear message from the Ninth Circuit was, look, Amy's Kitchen, they did it right. We're good with that. But you can still violate Medicare secondary payer if you do various things. And one of those things is following too closely onto what it is that Medicare actually does, or what the Medicare secondary payer requirements actually are. And we've seen a fair amount of that in the market. Personally, I think that's too cute by half, and I think the judges find it that way too.
Got it. So to wrap this part of it up before we get to questions, what are the bottom lines you can impart to plans, but also, and the next one will be the brokers, consultants, and TPAs they work with?
I mean, I think the bottom line for me to plans and their advisors, the brokers, and so on, is number one, you can absolutely do a dialysis carve-out. I mean, the very, very helpful thing that Supreme Court did in Marietta is say, yeah, you can do that. They didn't tell us how to do it, but they said you can do it. So that's great. I'm glad to have that one settled. But because the guardrails are still present, because we've returned to the pre-Sixth Circuit law across the country, you need to be aware of what those are and how to interpret those laws to get to something that's, frankly, easy to administer for the plan. Doing that requires working with somebody, who can digest all of this and has digested all of this into, here are the steps to follow. here are the things we'll do to support you, and here's something that we will defend and that you know can be defended because it's valid based on experience and analysis. And that gets you, frankly, the financial results you need to deal with what otherwise is a very financially harmful, circumstance.
Yeah. And then for health plans, and I want to maybe just focus, we already talked about steering clear of multiple of Medicare, but whether, curious your thoughts on following the guidance in Amy's Kitchen, but also not relying on PPO network discounts.
Yeah, great questions. Well, in the first place, as I say, I think Amy's Kitchen is now definitely the leading case, and they kind of went, I keep ringing the bell about what they said about Renalogic's language, because I think that's great. But having said that, they also went through a number of other discussion points that are very good to remember in terms of where the guardrails are. So it's definitely worth a read. And as legal opinions go, it's not that hard. I'd read it along with Virginia Mason to get your insights, because that will give you a better sense of what I mean by guardrails. Multiple Medicare, we've talked about that. PPO network discounts, couple of points to keep in mind there is that the PPO networks, they negotiate these discounts. They have something of an incentive to keep claims high, because then they can say that their saving amount, their discounts are getting the plan, something valuable, and they get paid a good amount when they're actually not delivering a good savings for the plan. And we see that all the time. And it's also the fact that the providers will put pressure on the PPOs to keep even their discounted amounts high. They need to balance the pressures they feel from providers. And frankly, in a lot of cases, you're going to see PPOs, I think, responding to the fact that the PPO sponsor also does Medicare Advantage in particular, PPOs, and they want those providers in those networks. And so the providers have a lot of leverage with the PPOs. So PPO network discounts, frankly, may not be all that they're cracked up to be.
Yeah, that's an interesting point, is that, a plan does business with a dialysis provider only insofar as they have a member on dialysis, but the network does business with the providers all the time, everywhere. And so they have, while they want to cut a good deal, they don't necessarily want to cut the best deal and provide the best discount.
Yeah, it's absolutely true. It's unfortunate, but it's true.
Interesting. Okay, let's turn our attention to questions. This first one is, just to be clear, at the end of the 30-month coordination of benefits period, the Medicare secondary payer law does allow plan to start paying secondary, whether or not patient has chosen to take Medicare, correct?
I think so. Now, what I'm going to tell you is that I think that's a difficult circumstance, because I think that there might be an argument about that. Plus, it leaves the patient high and dry, though, of course, if that's their choice, I guess that's their choice. But I think with Marietta, the risk of that being held improper is lower. It's not something that we specifically recommend, but certainly it seems like it's something that a lot of plans do, and we're not going to tell them that they shouldn't or can't.
Next question. This relates to the second takeaway, which is not to incent someone to go on Medicare, which is, have you ever seen the opposite, where DaVita and Fresenius create incentives for plan members to stay on the commercial plan / Cobra and not go on Medicare, so they can keep charging higher rates to the plan?
Oh, absolutely. This is sort of an interesting sideshow and an indication of one place that I think that the providers will go after Marietta. There's been a lot of activity around payment of Cobra premiums, in particular by the American Kidney Foundation, I believe it is. I may get that wrong, but anyway, by a nonprofit which is mostly funded by the dialysis organizations. And the point of that, of course, is that if a member can't afford or doesn't want to afford COBRA, which would be more expensive than just going on Medicare, they will step in and pay that, and then the member will stay on the plan, and the plan will pay the higher amounts than Medicare would. There was an attempt to at least get plans notice that that was going on and maybe put some limits on that through CMS, which regulates the providers in this space, and through a citizens initiative in California. And in both cases, that was beaten back by dialysis provider litigation. So basically, plans don't even get to know if this is going on, much less put limits on it. So that's definitely out there and definitely something that they're promoting and defending. Indirectly, I won't claim that the providers are making those payments themselves, but it's their allied institutions.
Thank you. Next one. Does this ruling make patients any less likely to be balance billed in the event that Medicare is active as secondary payer?
No, actually, patients should enroll in Medicare as soon as they're eligible. It's well worth doing for a lot of reasons, but one reason is that all dialysis providers participate in Medicare. I mean, when you look at the percentages of covered population that Medicare covers, it's fundamental to the business. So they all do that. And one of the conditions for Medicare participation is that you cannot balance bill patients who have Medicare coverage. And we've had a couple of occasions over the years when somebody at a dialysis facility has tried that. And frankly, a quick phone call to the CMS regional office gets them intervening very quickly to shut that down very fast. That's something we will do. It's an easy thing to do, and it's the best thing for the patient and the plan.
Thank you. There's a longer one here I'm trying to get through that maybe I have the person who asked it, and let me just capture this here so I can come back to it later. Maybe I'll answer that one offline. I guess we have time for about one more. So here's the last one, which is DaVita claimed this case is about discrimination, and that plans were discriminating against members. Is there any evidence in any of these cases that the actual services, the care provided to members on dialysis they received were inadequate or inferior after a carve or cost containment was put in place?
I've never seen or heard of that being the case. I mean, keep in mind that if you kind of don't necessarily know how outpatient dialysis is done, it's very much a commodity service. You've probably seen DaVita or Fresenius in a strip mall nearby. I've got one around here. And they've got multiple stations. They're manned by technicians under physician oversight, but the actual practical work is done by technicians in a very standardized way. And so there's just really not a lot of room for variation. Plus, it would be unethical in a way that could expose them to malpractice litigation by the patients. And that's another one where I think Medicare would take, CMS would take that very badly. So I've never heard of it, and I think there are good reasons to doubt that that will happen.
Thank you. So we're a little over on time here. I want to thank everyone so much for attending. John and I are happy to field additional questions. There's a couple that I saw that we didn't get a chance to get to. So some of them we have the person, some of them we don't have the person. But we encourage you to reach out. You can send it to this general sales email, but we'll make sure that one of us follow up with any questions you have related to Marietta or the practical takeaways. And if you're interested in learning more about Renalogic's suite of solutions that help health plans kind of contain and manage the human and financial costs of kidney disease, please reach out as well. We're happy to have those conversations. And we will see you next time on some upcoming webinars. Thank you very much.
Thank you.